Welcome, first of all, to the 2008 Coase lecture. I'm very grateful that you're all here. It's unusual for us to have laptops at a Coase lecture, but that's just a way of saying that some people here, for obvious reasons, think this is just another class that they're attending or something like that. But you'll quickly see that that's not true, and that this is really one of the special events of the law school calendar. It is meant to be a topic on law and economics aimed in particular at our first-year students. But as you can see from the presence of many faculty colleagues and others, it's much more than that, and we hope that it's a source of conversation and provocative ideas that we can talk about in the hallways and at coffee maps and anywhere else that our hearts desire. So our speaker this year, as you know from the poster, which I have trouble deciphering as it appears around the building, is Professor Lee Fennell, and she's easy for me to introduce because I feel like I'm her biggest fan. I believe that I have read every word she's ever written. I don't mean private letters, though people don't write private letters anymore, so perhaps I have read those as well. Professor Fennell is yet another example of our great taste in bringing new faculty to Chicago. And she has some experiences in training elsewhere. She has done time at Georgetown in Texas and Illinois and Virginia, and previously at Chicago as a Bigelow Fellow some time ago, where I believe I first met her earlier in both of our lives. But now she's here exactly as she belongs. And many of you have met her through property, and some of you have or will meet her through state and local government law or through thinking about the welfare state. And I hope that all of you have already met her or will meet her through her great writing. So it's a great pleasure to present to you Professor Lee.
Thank you so much, Saul, for that wonderful introduction, and thanks to all of you for coming. Is the sound too loud? Is that okay back there? Up a little bit. Okay. Sorry about the technical. Okay, how's that? Is that okay? A little better. Okay. All right. So one of the really great things about getting to do the Coase lecture, in addition to it being a great honor, is that you get to get this wonderful poster that is designed for it that tries to capture in some kind of a visual way what your talk is all about. And actually, in this case, I'm very delighted with this poster. I think you did a great job. The poster designers actually were more clued into the topic of my talk than maybe they even knew, because first they sent me a prototype that looked, that looked like that. As you can detect, there's a slight difference there, and I'm not sure why they decided to change it, but I really like having sort of both of these because this is really all about. Okay, so so slices and lumps. These sound like they are in fact nouns, but they're also verbs. And in fact, they can be sort of the answer to a question, which is what does a superhero invented by the property professor do to make the world a better place? Well, she slices and lumps. And the reason why this is so important, if we sort of imagine a superhero, the configurator, who goes about sort of slicing things up and lumping them together as needed whenever doing so yields more total social value, we can see that would be a very handy superhero to have around. And so I hope to convince you of that. Of course, if we were in the zero transaction cost world that Ronald Coase so skillfully rendered for us, we would all be able to engage in the configurator's tasks, sans, capes. But in the real world, we need a little bit more help with the task, and so that's sort of what this lecture is about. All right, so moving on, there's sort of 4 slices to the lecture, and you may experience it as one big lump. But first of all, sort of why lump, why slice? What do we gain from it? Difficulties and overcoming them. Legal lumps, sort of what it means, what are the legal implications of thinking in slices and lumps, and then what to do when all of the aggregation work or slicing work involves you and your other selves, sort of interpersonal dilemmas. Okay, so to get into this topic, first of all, it may be helpful to think of things that arrive in chunks that you might want or need to divide up. So a lot of young lawyers, for example, sort of complain that they wish that they could have a job that involved a little bit less work, even if it meant a little bit less pay. You may, at times, wish that you had a house that expanded only when you were entertaining, for example, or a car that materialized just when you needed it and was priced accordingly, or maybe a dog that provided half the affection and required only half the walking. Okay, so more on that actually in a moment. There's also a lot of things that maybe have to be split up. So maybe you're a co-owner of something, whether it's an inherited farm or maybe a couch in a group house that you live in, or maybe it's some kind of an interest in a business like a catering firm. And things have to be split up and you have to figure out how to do that. It's sort of a constant problem that comes up a lot in law. There's also lots of instances where things arrive in fragments and you would prefer to be able to put them together, either sort of acting alone or with other people. Lots of examples of this. You might want to put together money to buy something like a car, or you might want, along with other people, to put together contributions to create some public good, like maybe a bridge. You might also want to put together effort, create some kind of a result, like maybe a research paper, or a washboard abdomen, or legal reform, perhaps. You might want to put together votes to create some kind of a political result. You might need to put together patent licenses to produce something. Or you might wish that you could put together all the little pieces of extra space that you see in a line of parallel parked cars, that if you could just sort of put them together, there'd be enough space for your car. So, you can't do this. Law and markets can help us to some degree slice and lump, but you can't always get what you want configuration-wise. And sometimes that's the efficient outcome, because it's not all about what you want, right? All these slicing and lumping issues involve multiple claimants who have some kind of claim on the resource at issue, and you have to interact with them, even if those other claimants are only just other versions of you. You still have to interact with them, and it may be that on balance, when everyone's interests are taken into account, it's not efficient to actually reconfigure in the way you have in mind, once the costs of doing so are taken into account. On the other hand, we can't infer from the fact that configuration is in existence as it is that it's sort of the best one, because configurations can stick in place for not only for sort of good reasons, because it's the efficient configuration, but also for bad reasons, because of transaction costs. And particularly, we'll be talking about strategic behavior and the ability for that to keep good reconfigurations from happening. Okay, so to think about this question a little bit more, it's helpful to have in mind a tool from economics, and this is a very simplistic version of this tool, the production function. Okay, so here's a very simple production function here. Let me see if I can get that to disappear. Oh, that's not good. Okay, there we go. So here's a very simple production function. The idea here is to take some units of input and trace what happens in terms of output as you add more and more units. Now this is a simple linear production function where as you add units of input, there's a smoothly increasing amount of output. So to make this concrete, think of something like the contributions to a charity and how much good that charity manages to do in the world, right? So maybe it's linear like this so that you get sort of a constant return for each increment, or maybe on the other hand it is it is like this so that it sort of levels off so that you get less and less of a return as you add more units of input. Or perhaps it's like this, so that things are kind of slow to get started, but there's a snowball effect where you end up getting more and more out of the dollars. Or maybe it's like that. So there's a range in which there's increasing returns, and then a range in which there's decreasing returns. Okay, so there's lots of different possibilities. This is sort of a good all-purpose tool to have around when you're thinking about allocating inputs, whether to stack them together, split them apart. Sort of everyday decisions like, should I study another hour for property, or should I switch over to studying for torts, or how many people should I invite to a party, something like that. You might want to know something about the production function for the outcomes you care about, things like comprehension maybe, or revelry. Right? Okay, so we're concerned, especially in this talk, about production functions that are seriously lumpy, and the extreme version here is a step good, where you have a bunch of units of input before you get any return at all, and then you get a big jump in value, and then things level off. Okay, so the standard example of this is a bridge, right? Part of a bridge is not very good. You sort of need all of it, but once you have it all, you don't get much by adding more segments. So if it's a bridge that we think is generally worth building, then we want to get right to that unit of input number 10 without going over. Okay, so these lumpy goods can create two kinds of problems, and they don't create them uniquely. Other goods that aren't as lumpy can sometimes create similar problems, but these are often severe problems and interesting problems. First of all, they can be hard to assemble. If the people who own the input units can't all sort of get along, right? If the ownership's widely dispersed among them, then getting them to cooperate to create this thing may be difficult. And so you may have problems with people holding out if they have an essential part of the overall good. Also, even when we have a lot more contributors potentially than we need, we can have problems. And here you might think of public goods where you're trying to get people to contribute to something, and everyone sort of fears, probably correctly, that their contribution is likely to be either sort of futile, like kind of in the flat range where nothing gets produced, or superfluous, so that it won't be sort of the pivotal amount that actually makes the difference. Okay, so these can be concerns, one type of concern, sort of getting these lumpy goods together. They can also be hard to divide. So once you have something that delivers all of its value in one big clump, if you have to split it up, this can be a big problem. A sort of famous example of this is the dispute over the baby that featured in Solomon's decision. It turns out that babies are extremely lumpy. And so luckily, though, there's alternatives to physical division, and the Solomonic outcome was one of those. That was awarding the baby to the claimant who obviously valued the child more. Literature in this area has discussed a number of different possibilities, including things like temporal slicing, more on that in a moment. Converting the indivisible good into something that's divisible, like money, by auctioning it off. Or you can even have different sort of chances of the good that are proportionate to the claims of the different claimants that are distributed, and then sort of have a lottery for it. There's a lot of different possibilities. So temporal slicing is especially interesting because it addresses a mismatch between the sort of physical configuration in which a good delivers the most value and the unit in which it is most efficiently consumed by individual consumers. Okay, so it works well for goods that are more valuable when they're in one big clump, but actually that's not the unit in which people aren't willing to pay for that much. They don't want that much, and they'd rather have less. So if they can sort of share the good, that's one solution. We often see that. Clubs or communities that get together and have certain goods like swimming pools or tennis courts or clubhouses or even public safety, where you get the whole clump and then you share it. You can also have sort of market solutions that slice things up. We have things like rental cars, hotel rooms, even libraries that slice up books into lending periods. These are all examples of temporal slicing, and this can produce efficiency gains. And to kind of illustrate that, I want to focus on an example that actually there seems to be a company that now does something like this, pet sharing. Okay, so let's say that we have, here's a dog now. Let's say that we have somebody named Angus who gets diminishing marginal utility from having a dog. During the week, the dog is a lot of fun, kind of early on. You can kind of see these utility gains early in the week. But then over time, the barking, the constant need to be walked, the feeding and so on produces disutility later in a time. So what if we could slice up the dog week like that? And what if there were other people like Angus who had similar utility functions, such as Beth, Cam, and Doris? Then we could get these gains and not have this sort of disutility. Now, I'm not suggesting this is necessarily a great idea. It might not be so good for the dog who gets rather confused with all the different owners. He might never get properly trained. There can be disputes about who's going to take him to the vet, who's going to bathe him. So, you can come up with different solutions. Maybe whoever it is that's offering up the time slices can handle some of those tasks. But all the same, the point is simply that sometimes there can be gains from actually dividing things up, and this is true not only of lumpy goods that are split temporally, but other things that are maybe easier to divide, like cakes, can also produce more utility potentially when split up, and may not be entirely free of difficulties in getting the slicing done. Okay, so now that we have an idea of why reconfigurations might be valuable, well, why is it often so hard to accomplish, and what can we do about it? Slicing and lumping problems both begin the same way, we have some kind of resources, at least sort of allegedly, suboptimally configured. Okay, and so two things have to happen. First of all, we have to either aggregate consent to change it around into some different configuration from everybody who's kind of a stakeholder in that resource. So we either have to aggregate or we have to override their consent. And then the surplus that's produced from the reconfiguration, again, hopefully it's an efficient one, we hope, that will produce surplus. We have to divide up the surplus that is thereby produced. Now, sometimes these things happen at the same time. So if we have a developer who's trying to put together land for a development site, then when the price is paid for a particular parcel of land, that's sort of the way of buying consent, and at the same time determines how each party gets some share of the surplus that's thereby produced. But in other instances, we can imagine these things being separated out, and we'll talk about some examples of that as we go along. So one thing, though, to notice is that every problem of trying to lump, aggregate together entitlements, also involves something else. It involves splitting up surplus. Okay, and so by the same token, every time we're splitting something up, if there are multiple claimants who have some kind of stake in it, it also is going to involve aggregating consent, or at least doing something to override consent. Okay, so we can sort of see these as being sort of two sides of the same coin. Okay, so we already see kind of a sticking point here that aggregating consent can be difficult. Many parties hold stakes in the resource as it's presently configured. And so one way to think about this is in terms of Calabresi-Melleman's distinction between property rules and liability rules. If the interest in a particular existing configuration is protected by a property rule, then that means that each stakeholder effectively holds a veto over getting it reconfigured and may behave strategically in an effort to get more of the surplus that will result. Now, law has at its disposal ways to counter that. We can turn to liability rules that allow for the entitlement to be transferred without the entitlement holder's consent by payment of some amount of money that is usually determined by a third party, like a court or an agency. And so once we have those kinds of alternatives, we might say, well, you know, this reconfiguration thing doesn't sound that hard. We can always just override consent and split up the surplus any old way, and voila, we have the reconfigured thing. Well, you know, not so fast. There's some reasons to not want to do that. And one reason is that the tool that we would use to kind of overcome the bad stickiness, strategic behavior, will also cut through some of the good stickiness that we talked about before, which is when the reconfiguration actually would not add value. And that might be the case if, well, whenever we actually have a sale, we have at least some test that the person who's giving up the entitlement is getting something in exchange that they value more highly, so it gives us some certainty that it's moving to a higher valuing user. When there's consent being overridden, we don't have that kind of assurance. Okay, so just a little bit of a dramatization of this point. This is maybe a little too obvious, but I have the PowerPoint available here, so I'm not afraid to use it. If we imagine that the blue circles here are entitlements that should happen, or the efficient ones, and the white circles are ones that actually shouldn't happen. And that's because the entitlements are more valuable in fragments than if they were assembled. Well, you know, if we have this property rule here, right, you know, there may be some trouble getting over the bar, and some of the good ones won't make it through. We can lower the bar. We can make it a liability rule. That's all good. We get the good ones going through, but also one of the not so good ones. And this is something that lines up to a lot of problems that you'll run into in law, of sort of type 1 and type 2 errors, false negatives and false positives. Here's sort of the question of whether, if we have a choice between making things too easy or too hard, which way should we go? Just to make it a little bit concrete, if we have a land assembly problem and we have a fragment holder, Fran, who is essential to this development project, her fragment is, we have would be a similar Arnie who's trying to buy it and keeps offering her more and more money, 3-4 times fair market value. She keeps saying no. Well, there's a couple things that might be going on. One is that it might be an honest expression of her valuation. And if so, and if Arnie's not willing to pay it, then the configuration wouldn't be a valuable one. It's more like one of the white dots, and so we're not sad when it doesn't happen. She may be what Gideon Parchamovsky and Peter Siegelman have dubbed a hold-in. That is, somebody who's not strategically holding out, but actually has a higher valuation. On the other hand, she might really be a holdout. She might just be strategically claiming that she doesn't want to sell. It's just a ploy to try to get more surplus. And so she may just be bluffing. And in that case, the fact that the configuration ends up getting stopped would be a bad thing. Okay, so one thing to sort of think about this problem is that in competitive markets, we don't worry so much about this kind of strategic behavior about reconfigurations not happening because there's competition. So if a hardware store resists selling me a sprocket that I really need in order to fix my bicycle, you know, it's sort of an essential part, then that's not such a big problem if there's other places I can go, other hardware stores that I can go to get that sprocket. But a lot of these lumping and splitting problems actually involve instances where there's unique goods that you can't sort of go and get somewhere else. But even there, even when it's, you know, something like land that's unique, there still can be some differences that can tell us how great the risk is of a kind of holdout dynamic in a given case. Okay, so just to hint at the intuition here, you might compare a jigsaw puzzle, so sort of think about which of these things would be more fun. Okay, a jigsaw puzzle that's missing some of its unique pieces, that can still be like a lot of fun, right? Especially if you don't know the pieces are missing. You can kind of, you know, spend hours of entertainment putting it together. You know, maybe it's disappointing at the end. You'd like to have all the pieces, but it's still a lot of fun. Compare that with some kind of electronic toy that just won't do anything entertaining at all until it has all of its batteries, right? So that's a case where having sort of all the pieces matters a lot more. We can translate the same kind of idea into land situations by returning to this idea of the production function. So here, if we're trying to assemble land for a railroad, and we assume that there's just one viable route that it needs to take, then we really need all the pieces, or we don't have anything at all, and that increases the risk of holdout, okay? Because anybody can kind of try to resist giving us the sort of essential fragment. But maybe we're trying to put together land for something else, like a shopping mall. It's possible that the sort of production function for the surplus in this case takes a different shape, so that even if we can't get all the pieces, we still can get something pretty valuable. So, you know, we'd rather have 10, but if we have 9, then maybe it's possible to build around the holdout, or just make the shopping mall smaller, or something like that. So in these cases, holding out is riskier because you may not end up with the surplus, and therefore we're less concerned about sort of sticking with giving people veto rights to the reconfiguration. Okay, so in instances though where we're really kind of worried about overriding consent, or when we're worried about the holdout problem, what should we do? Well, you know, one thing we can do is override consent. Another thing we can try to do is get consent to a protocol for splitting up the surplus, sort of splitting apart those two elements that we looked at before. First, getting consent to a protocol for how you're going to split up surplus, and then later having the surplus actually divided up. So to make this concrete, here's a sort of well-known example where we have a protocol for dividing cake, right? So you have to split up a cake. What do? Well, there's a sort of famous solution here. Player 1 slices the cake into pieces, and player 2 gets to choose what piece to take. And so we don't know sort of exactly what each party will end up with when they agree to this game, but there's pressures that make it, that sort of push it towards being a fair game. Okay, so there's some concerns about this, and by the way, this can apply to things that are a little bit more weighty than cake. We can also use similar algorithms for dividing up things like marital property or inherited estates. But there's still some concerns about this. So, for example, if the player 1 here, who's the cutter, has some insight into the preferences of player 2 and knows that player 2, for example, really loves the lime slice, it's sort of a heterogeneous cake here, really loves the lime slice, then the player 1 can kind of can make the choice be, well, the lime slice or the rest of the cake. And this might seem kind of unfair. Now this kind of strategy is a little risky because player 2 might see through it and say, oh, you're just doing that because you know I like the green cake, and might decide to sort of stick player 1 with the lime sliver for spite, right, by sort of choosing the larger amount. So it's a little bit risky, and if parties are a little bit risk averse, then these kinds of solutions can give us some traction in these kinds of division problems. You can also have division of surplus protocols for dividing up sort of dividing up surplus when you're trying to assemble entitlements, like contributions to a public good. I mentioned before the fear when you're trying to assemble contributions for some kind of a step good that people may fear that their contribution will be futile or superfluous. Well, you can set up a protocol that says you make your contribution and you get your money back if we don't collect enough to actually create the step good. Or if we collect too much, we'll give you back a share of that, so that everybody is more in the position of providing the sort of pivotal contribution rather than having this kind of fear of it not being enough. There's other ideas that are kind of like this that have been discussed in the patent area. Doug Lichtman has talked about one, having some kind of a most favored nations clause, where a licensee who's trying to collect patent, who's trying to make sure that they have all the necessary patent licenses, would promise all of the known patent holders that they're interacting with that they will get at least as good a deal as any patent holder who later kind of emerges out of the shadows. And the idea there is to kind of tie together the distribution of surplus so that everyone is assured that they won't get kind of a bad deal and get kind of a sucker payout. Hey, let me just mention one other technique because it's kind of fun, called the Texas Shootout, which is used for dissolving a partnership. Let's say that we have partner 1 and partner 2 here, and they were partners. They decided the partnership would be better off in the hands of just one of them. So they're trying to figure out what to do about this problem. Well, this is sort of a solution. We can set up this protocol where partner 1 says how much partner 1 thinks that half of the partnership is worth, and this gives partner 2 a choice. Partner 2 can choose to exercise a call option, which means paying partner 1 the very amount that partner 1 stated, and then getting partner 1's share, so now partner 2 owns the whole enterprise. Or partner 2 also has the choice, when partner 1 gives the quote, of exercising a put option, which means that partner 2 is forcing partner 1 to pay the amount that was just quoted, and then effectively buying out partner 2's share so that partner 1 ends up with everything. Okay, so this sort of uncertainty about whether you're going to end up buying or selling creates pressures for partner 1 to give some kind of a fair valuation, and so it can help to counter some of these concerns about valuations generally. So these are all sort of techniques are all sort of part of a family of self-assessed valuation mechanisms that have been studied a lot in legal literature, including by some people here, like Saul Leavenworth and Richard Epstein, among others. The basic idea is really simple, that the person who has the stake in the entitlement is in the best position to say what it's worth. If we can just sort of find a way to get them to be honest. Okay, so one way to make them be honest is leave them uncertain whether they're buying or selling. You can try it for other pressures as well. One kind of famous example is the law of general average contribution in Admiralty, which required merchants to place valuations on their shipments. And that would have two implications. It meant that if your goods were lost at sea, you would get compensated that amount. It meant that if someone else's goods were lost at sea, though, you would have to help pay for those goods that were lost at sea based on a tax that was based in turn on your own valuation. Okay, so the idea here is that if you value your goods too low, they're probably going to be the very first things that are tossed into the ocean if there's a storm, and you won't get compensated enough. If you value them too high, you instead may get stuck with a really big bill for having to pay for somebody else's goods. Okay, now we can also imagine, I've talked sort of about these protocols being something people might consent to be part of, but you could also make them mandatory. And one variation, as my students know, that has been discussed a lot in the eminent domain context is having people value their own property and have that have implications both for what they get compensated in eminent domain and what they have to pay in property taxes. Okay, so there's a lot of issues that come up with those sorts of solutions, but it's at least sort of intriguing to think about how we might deal with these configuration problems in a way that's maybe more sensitive to valuations than would be a traditional liability rule. Okay, so let's go ahead though and talk about the next slice here. What are the legal implications of thinking in slices and lumps? Well, first and most obviously, the law can be involved in things like overriding consent and setting these kinds of protocols up. So we can have, for example, the tax system that forces people to make contributions so we don't have to worry about the bridge only being partially built. We can also have things like eminent domain that overrides consent in some circumstances. Also, there's legal rules that cover things like the partition of concurrent estates, with decisions made about whether partition in kind by splitting up the land or through a partition by sale that will sort of convert it into money. And those decisions have something to do with lumpiness as well. There's also things like employment rules that encourage certain kinds of slicings of jobs, slicings of work into jobs. Even when parties accomplish their own lumping or slicing through contract, law still may have a role to play. So for example, a talented and popular actor who performs for an entire season of a TV show may generate a lot more surplus than one who quits partway through, right? So it may have some lumpiness to the good. Contracts seem capable of making people commit to that, but what's to stop someone from threatening to walk off the set partway through unless the contract is renegotiated on terms that are more favorable? And this is exactly what James Gandolfino, the star of The Sopranos, did a few years ago. It actually worked, he got more money. Law can sort of determine by specifying contract remedies, it can have something to say about these things as well. Okay, another thing, the way that law sort of comes into play here is that law often speaks to circumstances or conditions or occurrences that have a lumpy or step-good quality. So maybe we have a fishery that's either going to remain above a sustainable level or it's going to enter a death spiral. We're going to have a species of animal that experiences a population crash or it doesn't. We have pollution that maybe if it moves above some critical threshold will create catastrophic results. So law may have a task of trying to aggregate together sort of enough units of care or forbearance to avoid the bad result and get sort of below whatever critical threshold is involved. And it has to find also a way to split up whatever surplus is gained by the society as a result of doing that. Another complication that comes in is when the inputs to these kinds of results are themselves lumpy. Sometimes people have to make binary choices about whether to do something or not do something rather than having kind of a continuous choice. And this can make a difference to how society addresses problems. To use an example provided by Thomas Schelling, suppose that we have a disease that can be optimally controlled if 90% of the population is vaccinated against it. Well, it's not really possible for everyone to be like 90% vaccinated. People can either be sort of all the way vaccinated or not vaccinated at all. And so if we make everyone do it, we might be overdoing things. If we let people choose, we might get too little vaccination. So maybe we have to come up with some kind of a system where we auction off no vaccination permits and put the proceeds, give the proceeds to everybody who actually gets vaccinated or something of that nature. To take an example from torts, if you have, for example, a bicyclist and an automobile that are on a dark country road at night trying to create a valuable good, a crash-free coexistence, their contributions are interdependent, as you know. They may also have lumpy qualities, too. If the bicyclist wears a reflective helmet, the motorist may be able to maintain a higher speed than otherwise. If the motorist has installed super effective brakes on the car, the bicyclist may be able to dress all in black and veer playfully around the road, and there may still be no accident, right? So some of these inputs that I've mentioned, like the kind of brakes or whether to have a special flashing protective helmet, are binary investments that an actor either makes or doesn't make, and others like speed or how far you are from the curb are continuous variables. And law has a lot to say about how to divide up these kinds of inputs, but in deciding how to do this, it may be relevant, in thinking about whether to mandate particular inputs or to tax or subsidize them, to think about lumpiness and whether a given party's sort of slate of choices comes from a continuous menu or whether it comes from a lumpy menu. Okay, so just sort of to adapt, I guess, Calabresi's phrase of looking for the cheapest cost avoider, we might also want to pay some attention to who's the cheapest cost precaution slicer, in a sense, who's able to sort of customize or scale their inputs to care. Okay, so all these things are kind of the law of lumps. There's also sort of a lumpiness of law itself that I want to just spend a little bit of time on. The idea here is that law can be sort of either tether together a lot of circumstances and treat them together, or it can slice up to apply differently to different circumstances. If we tie it to our production function idea, we might ask how a law's performance on different dimensions like clarity or salience or administrability or effectiveness bears on how much law, how many different circumstances are linked together, how thinly sliced it is. We can also think of law as an output that may, in fact, be easier, it may be costlier to produce a single law than to produce smaller single-purpose laws, or vice versa. And then we also kind of might think about this question of factory sliced or field sliced, as I put it here, which is the question of whether we want our laws sort of divided up back at the legislature, at the factory, or whether we want things sliced up in the field as things are administered and applied and interpreted, and even when decisions are made about their validity, sort of questions of severability. Slicing and lumping also comes into play in sort of conceptualizing law. As property scholars know, there's sort of this famous debate about whether we're better off thinking about property as a broad exclusion right that's wrapped around a thing, sort of a big lumpy thing, or whether instead it's better thought of as a bundle of sticks. It can be disaggregated, and those kinds of metaphors have consequences as well. Okay, so in the last little bit here, I just want to talk about intrapersonal problems of aggregation and division. So we see these same kinds of problems of trying to aggregate consent and split up surplus in these contexts as well. Let's say I'd like to get into shape, and doing so is going to require me to have to exercise 4 days a week for the next year, let's say. And this is something that I find, it seems attractive as a general concept, but really aversive in the implementation of it. And so the idea is I have to aggregate together these distasteful bits of physical activity into this result. And that means that there's not just aggregation, but also figuring out how to divide up those tasks and the resulting surplus. My individual selves are very crafty and are likely to tell me that any given day is not the best day to go to the gym. And also, none of the current selves are really going to get to enjoy all this great physical fitness because it's going to come later. And so they may say, why should I have to work for free? I mean, I'm not going to get anything out of it. There's also kind of, I do have a continuing identity, but there's a question of how close the relationship really is with my future selves. Derek Department's work has kind of explored this idea. There's also a problem that the results may take a step change. So there may be some level of fitness that's sort of noticeable or whatever, but short of that, I may not get much. And so if my current self knows that all of my tomorrow selves are really unreliable in going to the gym, they're going to have the same fear that people have about sort of giving futile contributions to a step-good project like a bridge. That it's all going to be it's going to sort of result in this half-built bridge, and it's not worth attempting. So how do we get the selves to aggregate these fitness inputs, for example? Well, I might try to turn over some of the work to a third-party enforcer who can kind of try to herd these selves in some way. And so there's sort of questions of how that might work. Well, interestingly, Stephen King, the horror writer, and Ian Ayres, the Yale Law School professor, both have taken a crack at answering this question. So first, Stephen King has a short story called Quitters, Inc., in which there's sort of this secretive clinic that has really good success rates for getting people to stop smoking and lose weight. It turns out that their methods involve violence. If you get into the program, then your loved ones may suffer electric shocks or having their fingers sliced off if you lapse. So this is quite bad. This is sort of the third-party enforcer coming in and punishing each temporal self that does not go along with the program. Well, now on to Ian Ayres' program. Along with co-founders Jordan Goldberg and Dean Carlin, he started a company called StickK, some of you may have read about on our faculty blog, for example, that's designed to help you keep your commitments to yourself. Again, sort of these commitments like not smoking or losing weight or exercising. The Ayres plan also has sort of a third-party enforcement mechanism to it. Let me just flip a quick thing here of what all is involved here. Basically, the current self signs a contract and puts up money. Then the selves, as they go along, choose whether to comply or not with whatever the plan is, exercising or dieting or whatnot. And if they fail to go along, then there are deductions from this amount of money that was put up, and it goes somewhere, like to a charity. It's not a charity that you actually get to pick, so it's a charity they pick. Or you can designate an anti-charity, a cause you really don't like, or it can go to an individual. It can even be a really hated individual. And here the idea is that you will be motivated to comply because you don't want to see the money go to these other destinations. At the end point of your plan, the future self gets whatever's left in the fund, if anything. Okay, so this is a far cry from electric shock, so I'm not really meaning to compare it to Stephen King's plan, but it still seems kind of hard on the selves. The current self is deprived of money right now, has to put it into this fund, and is asked to participate in this very aversive self-improvement scheme. If the plan succeeds, the future self gets both the money and the improvement. If the plan fails, the future self gets neither, loses money and doesn't get the improvement either. And so the whole scheme is sort of undertaken and agreed to by a version of one's current self. Here it's helpful to think of Hirsch, Sheffrin, and Richard Thaler's distinction between the planner self, that's really plugged into the long-range preferences that one may have, long-range plans, and the doer self, who's sort of in charge of the heavy lifting of actually acting in the world. And here we have the planner self sort of casting about for a way to get the doer self to do what should be done here. And here we have the planner self sort of picking up a stick and saying, you better do it, or I will do something bad, like give away your money to someone that you hate. If we sort of think about this problem in light of the reconfiguration steps we talked about here, first aggregating together consent and dividing surplus, we may be able to come up with some other alternatives. So rather than threaten the present self with a bad outcome, if she doesn't participate in the self-improvement scheme, which is sort of like trying to override consent in a sense, or force consent, while leaving all the surplus, if any, with the future self, maybe consent to the scheme could be bought from the present self somehow by the future self. So maybe we could have something like carrot K. How would that work? Well, let's just think about this. I'm curious to see what people think. The current self could sign a contract and put money into a locked savings account. Then, when the self at various points in time, T1, T2, T3 complies, a third-party enforcer is empowered to go into that savings account and pay predetermined rewards for that good behavior at preset intervals to the compliant self. And then at the end point, the future self gets full access to the savings account. So the future self in this story gets either the improvement, the sort of compliance along the way, or the money. The current self gets rewarded for going along with the plans, actually getting some of the surplus as a result. Now there's real questions of whether this would actually be very motivating. You might have to be pretty liquidity constrained for this to help. But it might actually work if you put enough money into this locked fund, because maybe you want to go do something and you need money and you have to go to the gym in order to earn it from this third-party enforcer that you deserve to get the money. So it's at least worth thinking about. One other possibility deserves a quick mention, and that's the possibility that the law might assist people in making pre-commitments and sticking to them. In other words, help them in these kinds of self-aggregation projects. So in Illinois, for example, people can actually put themselves on a self-exclusion list that will be a way of banning themselves from casinos, and also I think from being able to win lotteries. We can imagine more fine-grained versions of this idea. Jay Bhattacharya and Darius Lakdawala proposed a voluntary smoking license that was designed to actually allow people to opt into making smoking more expensive for themselves by effectively giving them a cigarette tax. A variation on this, sort of my variation on this, is a choose your own sin tax that might work like this. Under my scheme, you would actually be required to get a license before you could buy cigarettes at all. You'd have to go and get this smoking license that would be free. And at the time that you went to get the smoking license, you would choose a cigarette tax. You'd be forced to do this. And you could choose 0. You could say my tax is 0. That's fine. But if you were interested in pre-committing, you could choose a positive amount, and moreover, you can at any time raise the tax. As you go along, maybe during moments of regret about smoking, you can raise your tax. And then the way that this works is the tax would go into escrow to cover any smoking-related illnesses that the smoker might later experience. But at any given time, the smoker can obtain all the funds in a lump sum by surrendering the smoking license. So this would effectively work kind of like a Pigovian tax, a tax that's designed to charge for externalities that someone is inflicting on someone else. Here, the smoking self is inflicting costs on the non-smoking self, and as soon as the non-smoking self sort of comes into being, the non-smoking self is able to collect those taxes. Now, there's some complications. What if people want to smoke more after they surrender their license? What do we do? What if they want to lower the tax rather than raise it? What do we do? But all the same, it's worth sort of thinking about these kinds of alternatives, and specifically about the way that the law might creatively try to facilitate people's own attempts to aggregate their own efforts together. Okay, so these kind of slicing and lumping problems are, in fact, everywhere. And you knew that before the lecture. But what I've tried to add here is a little bit of a structure for thinking about them and some tools for spotting them and responding to them in law and in everyday life. So I welcome your questions.